Dive in. As Amy mentioned, today we'll be discussing the Foreign Extortion Prevention Act and its implications on U.S. and Indian companies. The FEPA was signed by President Biden on December 22nd, 2023, and amends the domestic bribery statute to make it a criminal offense for foreign government officials to solicit or receive bribes from any person in the U.S. But actually, I'll let our speakers and experts actually go into the details and implications on U.S. and Indian firms. And so we're joined today by Catherine Sawyer, counsel at Latham and Watkins. Catherine is a formal federal prosecutor and an experienced trial lawyer who represents clients in white-collar litigation, and government investigations, and additionally advises clients on investigations related to the Foreign Corrupt Practices Act, cross-border M&A, and capital market transactions. And we are also joined by Panag, partner at Panag and Babu. Sherveer is the leading expert on Indian anti-corruption compliance and internal investigations, chairing Panag and Babu's compliance and investigations practice, and has extensive experience in defending multinational companies in matters involving criminal and regulatory proceedings. And so both of them are the true experts on this matter. And so I'll actually kick it over to Sherveer to start us off.
Thank you, Peyton, and good morning and good evening, ladies and gentlemen. It's an absolute honor to be here with the USIBC and my colleague Catherine Sawyer from Latham and Watkins. Let me just start by setting stage. Most of us in India and in several jurisdictions have sort of started seeing the synonymity between international anti-corruption enforcement and the U.S. Foreign Corrupt Practices Act, or the FCPA. And the enforcement efforts led by the United States Department of Justice and the Securities Exchange Commission have in turn impacted enforcement priorities, enforcement objectives, and enforcement styles, mind you, in several parts of the world, from coming into settlements or when legal systems conflict with each other, like they do when it comes to India and the United States on matters of deferred prosecution agreements or settlements. We've seen a lot of activity, and for most part, there'll be critics who there'll be academic critique on the manner and mode of prosecution styles. But I think for most part, the FCPA has played and earned itself a place in history when it comes to global anti-corruption, the global battle against corruption. And now we have at a last-minute amendment, a last-minute signing into law of the FEPA, or the Foreign Extortion Prevention Act, bringing in the element of dealing with the demand side of bribery as opposed to the supply side of bribery, as some would like to call it. I see this as also a very interesting dynamic in the overall picture of foreign bribery enforcement, as domestic bribery has always viewed the official receiving the bribe as a key target of any prosecution, as in that's how most common law countries have built their law. But the foreign bribery laws never really got there. So I think this is a very interesting step in that direction. And I think the star of the show really is going to be Catherine, both with her former government experience and the work she does at Latham. And I'm effectively going to be serving as someone who's going to help navigate the more India impact questions to Catherine. So I think, Catherine, just to sort of kick things off, how does FEPA tie in with the FCPA? What should we and what should companies be reading into the timing of how this legislation was passed?
Thank you, Shabir, and also thank you to Peyton and Amy for having us here today. As Shabir said, it's an honor to be with you to talk about this subject today. So let me just step back momentarily, and we've got a PowerPoint to share with you. I think what would be helpful in talking about FEPA and talking about its place in sort of the anti-corruption infrastructure is to just do a very quick refresher on the Foreign Corrupt Practices Act, what it is, and then perhaps importantly in transitioning to today's subject, what it is not, and the gaps that it left that were filled by FEPA. So if we can just quickly tick to the first slide. So this is just sort of where we'll work through today and end up with implications and some discussion both about implications globally, implications in India. We can go to the next slide. Thank you. So again, I'm going to go through pretty quickly here. This is just a little bit of a refresher for everyone on the Foreign Corrupt Practices Act, where we've been for the last couple of decades. We see criminal and civil enforcement, both from the Department of Justice and then on the civil side from the Securities and Exchange Commission. Generally speaking, Foreign Corrupt Practices Act applies to U.S. companies. That's companies with headquarters in a principal place of business in the United States. U.S. issuers. Importantly, that often will mean not only U.S. issuers in terms of sort of listed on the U.S. exchanges, but also foreign private issuers, U.S. persons wherever they're located. And then we get into sort of the broader application of the statute, which is anyone carrying out an act in furtherance while in the United States. And this is the piece that has provided some very broad jurisdictional theories to the Department of Justice. And then there's been some movement on the conspiracy piece, but conspiracy and agency theories have also provided jurisdictional grounds to DOJ for a pretty broad application here. Okay, next slide. All right, this is, there's a lot on here, but this is basically lays out, what does the FCPA say? And at its most basic, essentially, and again, for this group, this is likely something that you're already familiar with. So just very quickly, it broadly prohibits improper payments of anything of value, very importantly, directly or indirectly, to non-US government officials in order to obtain or retain business or secure an unfair advantage. And we just sort of build out some of the more key provisions here, particularly those that have been broadly interpreted by the DOJ. And so that's in terms of thinking about things of value, and you'll see this will apply also with respect to FEPA. Things of value have, there was a moment in time where we thought about bags of cash and we thought about, bribes in a very specific way. And as time has moved on, schemes have gotten more complicated and more sophisticated. We've started to see the thing of value evolve into things like discounts, for example, charitable donations, political contributions, sponsorships, consulting agreements. So really think about that broadly, and that will apply with equal force in the context of FEPA. Then the question of who's a government official, and again, we'll talk about that in the context of FEPA because that looks a little bit different now. That's obviously, folks who hold a governmental position. I think a lot of times when the people in the business world think about foreign officials, it's easy to think about someone senior or someone with, sort of a large outsized role. But generally in the everyday FCPA matters that we see, what's much more likely is that we're talking about a fairly low level or mid-level municipal employee, or, someone with the authority to stamp a form. And so really, again, we're going to think broadly about who constitutes a foreign official. And same goes for particularly in countries where state-owned or controlled enterprises are common. That's another place to really think broadly. We can go to the next slide. Okay, I'm going to be quick here. This will also apply when we talk about FEPA. So the payment to an official can be indirect or direct. Very commonly, obviously, we see a scheme by which a company will make the payment through a third party. Somewhere in the neighborhood of 90% of FCPA cases that we see have involved at least one or more third parties. And so when we get to implications for corporates thinking about this, I think there's going to be a real need to rethink training and compliance programs, particularly with respect to third parties, as we've been doing for some time. So again, this is very high level, but under the FCPA, liability can attach where the payments are made while knowing, and this is again a fairly charitable standard to the government because it's where there is a high probability that the conduct could occur, and companies have an obligation to not avoid actual knowledge. So where there are significant red flags, the government can essentially assert that constitutes knowledge. We can move to the next slide. Okay, and again, this will be relevant where we talk about distinctions between the laws. So the FCPA has two pieces: the accounting provisions and the anti-bribery provisions. So with respect to the accounting provisions, this is where the SEC comes in, and we are not going to see that in the FEPA context, as we'll see. We can go to the next slide. All right, this is just high level on consequences of non-compliance with the FCPA. Penalties here worth noting for individuals: $5 million for accounting violations, $20 million, $250,000 per anti-bribery violation, disgorgement, and then the sort of reputational disruption consequences on the left side, where, setting aside whether there is an actual violation that the Department of Justice can prove, all kinds of consequences, irrespective of liability, where, you're looking at ongoing sort of disruption to business, investigations, reputational damage, even where there's no violation proven. And again, that will be a sort of a similar consequence to be thinking about in terms of these investigations as we talk about them in the FEPA context. Next slide. Okay, this is really just to make the point, and we won't spend a lot of time on this, is just how broad a stance the DOJ has taken with respect to its jurisdiction under the Foreign Corrupt Practices Act. That broad approach to its jurisdiction nevertheless had gaps, which we'll talk about in a moment, and sort of particularly in the context of how we got where we are today. So if we can move to the next slide. Thank you. Okay, so just by way of transition now, in talking about what gaps we saw in the FCPA, as Shabir previewed early on, essentially what FEPA does is seek to address the demand side of bribery. And so before FEPA, neither the FCPA nor the U.S. domestic bribery regime addressed the bribe seeker or the bribe acceptor. And so there was no provision by which U.S. prosecutors could directly approach bribery on the demand side. And so what did we do instead? We saw money laundering prosecutions, we saw wire fraud prosecutions, conspiracy to commit money laundering. And so for the foreign official, those were the charges that you would see in the United States. And in fact, just before, I want to say there were maybe 2 prosecutions of foreign officials in the months before FEPA was passed in December, and maybe 6 in the year before or so. And I say those numbers loosely, but in any event, the gap was there was no tool to take that head on. And so what they were forced to do was to use money laundering and other domestic statutes to address that conduct. So what we saw, and I guess we can go to the next slide, that takes us then to FEPA, which, as you've heard, was passed in December 2023. And I think now, getting back to Shabir's question, the way that FEPA sort of ties into the FCPA is it addresses directly that void that was left by the FCPA in terms of how to treat the foreign officials, how to treat the solicitation conduct or the receipt conduct. And so now prosecutors have a very clear, very direct, I shouldn't say easy, because there are some issues with it that we'll talk about, but a much more bespoke, tailored approach to these kinds of offenses, and will no longer, in theory, have to go around to use the money laundering statute to reach some of this conduct.
So, Catherine, before you sort of dive into the key elements of FEPA, just to sort of question out there, in terms of the overlap. So if, hypothetically speaking, there's going to be a charge brought against a foreign official under FEPA, how do you see that translating as a defense to an organization under the FCPA? Is it an absolute defense? Is it likely to be viewed as a mitigating circumstance? Where do you sort of, how do you sort of see that playing out? I know I'm sort of giving you the tea leaves and a crystal ball to gaze into the future, but any thoughts there would be much appreciated.
Well, it's an interesting question, because I think it could potentially actually be sort of the opposite, right? Where it's I think it depends. It depends, which is what a very lawyer answer, right? But I think it can be an opportunity for companies. The DOJ has, in the last few months especially, and in this past year, we've seen changes to the corporate enforcement policy. That it's very clear that they want to further incentivize self-disclosures. And so where a company may have discovered an issue or misconduct within the company as it relates to the FCPA, I think, and this will come up in terms of the implications, but I think it gives companies interesting leverage in terms of their ability to cooperate with the DOJ and provide the DOJ with information about those officials. Whether it provides a defense is interesting because I think it depends on the facts. It depends if they accepted the bribe, if they're just reporting a solicitation. So I think, again, to your point about the tea leaves, it will be interesting to see where this goes and how the government uses it. But I do think it will provide interesting new cooperation opportunities. And I guess I shouldn't say new, whether they're truly new or not, because I think what remains to be seen in a lot of the discussion that has been had in the community on the U.S. side is how much of a difference will this truly make, right? Practically speaking, will DOJ be able to? Will they bring more cases? Will it actually enable them to do more than they could with the money laundering statutes and the wire fraud statutes? And I think that will be interesting, but it remains to be seen whether they will truly be more active on this basis.
Understood. Sorry to break your flow. Back to FEPA.
No. So I think the next question was, I think, going to be simply sort of what is it? What does it say? And so we've pulled out sort of the key terms in big pictures. And so you'll see it looks a lot like the FCPA. It's structured in a similar way. Many of the key provisions sort of mirror the provisions in the FCPA. So here, as opposed to a U.S. company, obviously, it prohibits foreign officials, and the sort of the intent standard is the same as it is in the FCPA. So corruptly, demanding, seeking, receiving, accepting. So here you see the solicitation side of things, or agreeing to receive, accept anything of value. So importantly here, it is not only the conduct, but it's the agreement too. So it now becomes an offense just to agree to accept a bribe. So even if I'm not actually paid, just the sort of acceptance, like the solicitation of that thing of value is also an offense. Then here again is the nexus to the U.S. So from any person while in the United States. So if that foreign official is traveling and is here in the United States, if the company is a U.S. issuer, again, on the U.S. exchanges, or is a domestic concern, which means it's a U.S. company, whether or not it's public. And again, similar language here. So in return for, and this is where there has to be a quid pro quo, right? So the foreign official has to take one of the actions in the top box, seek, receive, accept, or agree to do that, something of value. And again, I think we're going to see a similar expansive application of that like we did in the FCPA context on the earlier slide. Then in return for being influenced in the performance of an official act, being induced to do something, or conferring any improper advantage in connection with obtaining or retaining business. So again, this is why we wanted to talk early on about the Foreign Corrupt Practices Act, so that you could see it against the backdrop of FEPA and could see those similarities. Penalties here, what's interesting to me on this is a fine of not more than $250,000, but then 3 times the monetary equivalent of the thing of value, and then imprisonment up to 15 years. So if we look, for example, at the other tools we talked about, money laundering, wire fraud, money laundering, the offense is 20 years in prison, $500,000 maximum, or 2 times the amount involved in the transaction. So if you think about a monetary penalty, if there's a money laundering offense, that's usually one transaction. So someone moves money from point A to point B, and your offense is potentially twice the amount of that individual transaction. But here, what we're going to look at is 3 times the equivalent of the entirety of the thing of value conferred on the government official. So if the bribes are in the millions of dollars, then you're now looking at 3 times that as the maximum penalty, which again, this is highly factually dependent, but in a money laundering count, usually there are multiple counts in smaller amounts. So it is entirely possible, I think, depending on, again, highly factually dependent, but you could be looking at a lot of money at the end of the day in terms of the penalties here. Okay, so here's where we are going to see one of the key distinctions. We've talked about sort of what is a thing of value, what is a, what's the jurisdictional nexus. So here, FEPA's definition of foreign official in a lot of ways looks a lot like the Foreign Corrupt Practices Act. However, it includes senior foreign political figures, which is more broadly defined, and it includes people acting in an unofficial capacity for or on behalf of a government, department, agency, instrumentality. So in some ways, what we're going to see is a much broader reach of the definition of foreign official. And I think to one of Shabir's questions, and we'll talk about this in the context of implications, it's going to require a lot more sort of attention by the company as to who you're dealing with. Now, that does not, nothing about FEPA has changed liability on the Foreign Corrupt Practices Act side. So one thing to be careful of here is this expansive definition applies to the liability of the foreign official. It is not going to then give rise on the company side to liability under the Foreign Corrupt Practices Act unless there's an overlap of the definition of foreign official, right? So if it's an official of a foreign government, liability on both sides. But if it's a person acting in an unofficial capacity on behalf of these people, then we're looking at only FEPA. So it gets a little bit complicated as to sort of whether we're going to look at the foreign official or whether we're going to look at the company. But generally speaking, what this is doing is expanding DOJ's reach over the liability for the foreign official in a way that would not have previously provided liability on the company's part under the Foreign Corrupt Practices Act.
So just a follow-on question there, Catherine, as I was sort of going through the expansive definition, I completely agree. It looks a lot like the sort of expansive definition that probably didn't come from statute, but came through enforcement precedent under the FCPA. But I think the central question is that there's a lot of, there seems to be a posturing alternative to diligence here, that one needs to go much deeper to understand who the foreign officials are, what influence they could put in. And as you know, world over, law firms, accounting firms, PR and strategy, government affairs firms always have, former government officials joining them. So how do we sort of balance this overarching element that's been placed there with the expansive definition that comes in here? Are those transactions on the face of them going to become risky? Is there going to be a need for more documentary diligence associated with them? How do we sort of, how are we going to thread the needle on this one?
Well, I think that's right. And so when we get to the implication slide, that is certainly, I think, an issue that the company will want to think about. And again, I mean, I guess this is where it is the delicate balance, and it's going to be, we're going to need to take some cues as we start to see the Department of Justice use this tool. If someone, again, the liability on the FEPA side is in some ways broader for the foreign official than it is on the FCPA side for the company. And so if someone fits into sort of, FEPA bucket foreign official, but not FCPA bucket foreign official, then that's less of a concern for the company. But to your point, you're right. I mean, and I think part of what people are going to have to do on the company side is uplift things like trainings, things like diligence process, or third-party government diligence, to be sure that we're comfortable. And again, this is all from a risk perspective, right? It's not necessarily, that we're comfortable that someone is more likely official type A as opposed to official type B. But you're right. I mean, it's something that they're going to, I think, have to think more closely about and spend more time on.
Thanks, Catherine. I think we should probably move to implications and enforcement trends and get your perspective on where do you sort of see this, how do you see this landing? Do you expect this to be a sort of, you know, heavy enforcement, aggressive enforcement, hot start, or something more like a cold start? You know, the FCPA came out in 1977. I think prosecution and enforcement trends that we've become globally familiar with are more sort of elements of the early 2000s onwards. What's sort of your prediction as far as FEPA is concerned?
So as ungratifying as this will sound, I don't have a great answer to that. I don't know. I think largely it will depend in some ways what's in the pipeline. And so I think sometimes when, commentators in the articles will come out about, well, this year was slow or this, it's hard to know what's in the pipeline, right? And so we saw an uptick. The first few months of 2023 were quite slow. And then there was an uptick towards the end of the year with FCPA enforcement action sort of coming out close together at the end of 2023. It will be interesting to see because obviously these investigations at DOJ are not public and companies often are not disclosing unless they feel they have to, and it's a public company and they've got those requirements. But, if there are ongoing investigations in the pipeline, this now gives DOJ a new tool. It's very possible, certainly, that they could see sort of a quick succession of cases under this statute come through. One of the interesting parts is I do think that this gives DOJ sort of additional leverage in terms of cooperating, either individuals or companies providing information. Again, this recent DOJ guidance has expanded the amount of cooperation credit that a company can get under the corporate enforcement policy. And what we've sort of seen in the few resolutions that we've had since that update, they've expanded the cooperation credit to 50%. But what DOJ seems to be expecting of a company to earn that full 50% is new information that the department perhaps didn't have previously, making cases against other companies or other individuals that the DOJ feels maybe they couldn't have made alone. And so there is this sort of X factor in the cooperation built into that extra cooperation credit that I think this maybe now will give companies some additional leverage to say, look, I can give you information about the foreign official. And if DOJ couldn't perhaps previously have made a money laundering case, because remember, in money laundering, there has to be a transaction in the United States. So now there's an additional tool which could give companies an additional opportunity. So it could well be that companies who are sort of in the pipeline and currently talking to DOJ, currently cooperating with DOJ, additional impetus to, provide information about the foreign official they were dealing with. So again, it's an it depends answer. And I think, another issue that we're going to see on the implication slide, what will be very interesting to see, and I don't know that this is truly all that different from the money laundering context, but it will be interesting to see sort of the interplay between this statute and just sort of U.S. diplomacy relationships with certain countries, because I think there will be diplomatic challenges that exist around this. And, whether it looks all that different than the existing challenges around money laundering, hard to say, but there is something atmospherically different about saying your foreign official took a bribe versus this money went through a bank. And, there's something about money laundering that is less direct and less obvious. And so even though there's not a tremendous, it's not if there's, it's still a crime, it's still unlawful, there are still penalties, but, there is something atmospherically different about bribery. And so, it remains to be seen, but I think there will be some interesting diplomatic elements to this as well. I think we can probably go to the next.
May I just put a follow-up on that, Catherine? Just would you see this? Would you see sort of in the genre of corporate enforcement and prosecutions? Would you see the equivalent focus that a Yates memo or a Rosenblum memo or a Monica memo having um, on sort of individuals and sort of bring for corporations to sort of bring out um, you know, provide a spotlight on individuals responsible for conduct. Would you sort of see a similar segue being built under FEPA where cooperation would entail that? And would you see this first getting memorialized at a memo stage? Would you also see this as a posture of saying that we would like you to throw light on foreign officials involved?
I think it's possible. I mean, look, I think the DOJ has been quite clear in the last few, in the last year, certainly, about its focus on individual responsibility. It goes hand in hand, candidly, with sort of the Biden focus on, anti-corruption as a national security tool. And so, I don't know if we'll see a memo on this or that we'll see it soon, but I certainly think that it's right in line with the DOJ's stated goal of seeking individual responsibility in these cases. And candidly, when we think about individual responsibility, who is a better candidate for individual prosecution than the foreign official who took the bribe, right? I mean, usually it's a rare case. And we saw, for example, there's one out of Ecuador recently where there was the former head of a state insurance company. It's not every day that a foreign official is charged and then cooperates with the Department of Justice. Usually when we're talking about individual responsibility, often it's the third party and not the actual official. And so I do think that, this falls nicely in line with DOJ's goal of individual accountability and individual prosecution. So, whether there will be a memo or not, that remains to be seen, but this is certainly consistent with what we've seen in the policy and guidance coming out of the DOJ in the last year.
Got it.
I think we can go to the next slide. Okay, so we've already touched on many of these, but let me, Shabir, and I've talked a lot about the United States, so obviously sort of this is DOJ as an actor to enforce FEPA, and we can talk some more about what that might look like. But from your perspective, what's the feedback? What are you hearing in the community in India? What's the sort of, how has this been received?
Thanks, Catherine. I think too soon to say in terms of how we're going to what the overall response to this is going to be. But I would say that we've generally viewed the FCPA positively. I think the FEPA carries significantly new connotations, I think very diplomatic ones. Ultimately, even if the DOJ does bring a case, it's going to be something that sort of ties into extradition. And that's going to be very, very challenging to bring about. But I think at its core, this is something that India has been on the other side of. So our anti-corruption law for the longest time was more on the demand side as opposed to the supply side. It focused on government officials. We've also started recognizing provisions following a 2018 amendment to our principal anti-corruption legislation on looking into similarly placed extortion elements and reporting them and getting an absolute defense in the event that you do report a situation where you were forced or compelled to pay a bribe. And I think the Indian experience on being forced or compelled has generally been a much easier and cleaner defense than I think sometimes we've challenged within sort of defending this under the FCPA. But I think the FEPA, with an operative word being extortion used, is likely to change that experience. So I think at a principle level, on the universality of the principle of should the demand side be prosecuted, I don't think there would be any challenge. But I think the slip between the cup and the lip is really going to be with the challenges on how effective it can be with countries like India, Germany, the United Kingdom, where diplomatic relationships between the United States and India have been very different. But I do think when you spoke about the very expansive definition of a foreign official and those who are acting in an unofficial capacity, either collecting money or being or passing through, I think that's where uh, a, a distinctive class in terms of those acting in an official capacity versus those who are actually government officials, I think um, is going to be, I think that distinction is where we may see proclivity to sort of support one over the other, is how I'd put it.
Yeah, that's a good point. One thing I think will be interesting on the diplomatic front is how much sort of political capital will you want to expend to seek cases against, for example, or extradition against, often these folks are not particularly senior, they're not particularly high ranking. And so it will be interesting to see how this is used and whether it tends to be, as you've said, sort of these unofficial actors, or whether it will be used to really pursue significant targets. And I think that will be interesting.
I don't know, we're in a wait and watch mode.
And so I've touched on this a little bit, but I guess for the benefit of our audience here, some of this will be universal, I think, across the board to corporates, regardless of what country they're in. And we can talk sort of more broadly about what companies should be thinking about. But so how do you see foreign companies generally, and then Indian companies more specifically, how do you think they should be thinking about this and what steps they should be revisiting or thinking about given FEPA?
Thanks, Catherine. I think to start with, I'd say that, in an ideal world, an existing strong anti-corruption program which sort of follows the universal principles that the DOJ and SEC have spoken about in different guidance documents, as well as what sort of in different shapes and sizes and forms other bodies across the world. The UK Ministry of Justice, came very close. In India, we've not had formal guidance yet, but it's something that's sort of in the pipeline. I think all those principles, whether it's diligence on third parties, know how you're getting across, decisions regarding government sales, tone from the top, trainings that are just not tick the box, and more behavior altering compliance mechanisms as opposed to merely liability reduction policies and forms. I think a strong anti-corruption program and a strong anti-corruption compliance program will sort of tick all the right boxes. But I do see a larger onus on organizations on the diligence side, especially when they're working with third parties who could have relationships with government officials. I do see the onus coming onto organizations with, unfortunately, not too many solutions in terms of the availability of information. Some countries or some government departments will publish who the list of officers are. Some officers may be so senior that you're able to make that correlation. But otherwise, it's really a sort of diligence black hole when it comes to be able to figure out whether a third party has a key managerial personnel or a director or an ultimate beneficial owner who could have had a career in government for some point of time. So I do see that. I'd say first principles stay first principles. I don't think we're going to be adding a new first principle, but diligence would need to become a lot stronger. And I don't think we have all the solutions when it comes to diligence in several countries, including India, in terms of just knowing who government officials are. But I will say, Catherine, with all these problems and there are two good things. I think number one is I do think companies are going to have more elements in their, more arrows in their quiver to sort of, push back on bribery demands, on also laying out not just that, hey, I'm a foreign company, or hey, this is not something that we want to do, but a little, 2 steps forward in saying this is something that could result in individual liability for you both in India and outside India. Now, look, these conversations sound much easier in webinars, and these responses sound much nicer and have a very different ground reality in several parts of the world. But I do think that at a global level, this will help that conversation significantly, and I do think the third parties will see a lot more spotlight, and also I think we'd have probably a greater impetus with what we can hit back with than what we had earlier.
I think that's exactly right. I mean, we'll see how this plays out, but in terms of corporates who are dealing with government officials, for whatever it's worth, I think that atmospherically it is much easier to convey to a foreign official that this is now just asking for or accepting a bribe is now illegal in the United States. Good luck trying to explain, well, if you take money and then funnel it through an account in the United States, and trying to explain how money laundering is very, very difficult and much more abstract. And so I think this does, at least in some measure, give companies an easier, more concrete response to those officials than they would have had in the past, where you had to, the United States is relying on abstract laws like money laundering, which sort of probably don't resonate that much with particularly the folks that we're worried about in non-US countries. And on the extradition front, not that this is any different in the money laundering context, but some of the reaction that we've heard following FEPA is, well, the countries where this is happening, there either isn't extradition, or is the foreign country really going to agree to extradition under these circumstances. But it just gives the US government one more tool to, for example, freeze assets. With a US indictment, people's travel would be highly limited. And so even if you can't get to the point where you're extraditing some of these folks, hopefully there is still a significant deterrent effect to simply being, for example, under an indictment in the United States in terms of your ability to travel and your assets, et cetera. And so it stands to reason that we may see at least some additional deterrent effect from this statute.
I completely agree with that. I think that there's definitely additional deterrent effect, and I would also add that I think one of the elements that the FCPA started conversations in several jurisdictions that probably due to social economic circumstances were several years away. And I see FEPA similarly, if there is going to be strong enforcement, likely starting similar conversations. It's going to be very difficult to. It's going to be an interesting legal complexity, because the offense has happened in a national jurisdiction, unless it hasn't and happened on international waters. But it's an offense in that jurisdiction, and an extradition request, what's going to take precedent? Is local law going to take precedence? Is an offense that's committed that for the same act, there's a local offense and then there's a foreign offense? What's going to take precedence? Will extraditions legally even be possible? But I do think they'll start important conversations, and and sometimes in the larger scheme of things, if I had to philosophize in the fight against corruption, starting conversations are good starting points.
I think that's right.
Just to jump in real quick, I know we have a couple of questions in the chat from the audience. The first is on extradition, which both of y'all just touched on, but just want to read it out loud for the benefit of the audience. It's, will the extradition treaties also come into picture? Let's say if the DOJ wants to imprison someone as a punishment. Catherine and Shervir, both of y'all have touched on that. I don't know if you have anything else to add. And the second question from the chat is, how would FEPA deal with illegal transactions using cryptocurrencies to pay a corrupt official?
So in terms of extradition, yeah, I mean, I think, look, extradition always poses, well, let me take the question sort of as it's drafted. Extradition treaties will always come into the picture when the U.S. is seeking to charge and extradite someone outside of the United States. And so I think the simple answer to that is yes. And I think I've touched on this a little bit, but if there is no extradition treaty, then obviously our resources are limited, though, as I've said, a U.S. indictment, even if they can't be extradited from their home country, a U.S. indictment would still place serious limitations on sort of their freedom of movement, their ability to move assets around. And so, for example, if someone under indictment in a country that does not have an extradition treaty with the United States travels internationally, they could be arrested in a country that does have an extradition treaty with the United States and brought back. The fact of a U.S. indictment could potentially put pressure on foreign governments to bring domestic prosecutions against those officials if they're unwilling to extradite them. It could provide a basis for certain sanctions against foreign officials. That's not my area of specialty, but it provides tools even absent extradition and pressures that I think can be brought to bear even where extradition poses a challenge. Shabir, I don't know if you have thoughts on cryptocurrencies.
No, but I think at its heart, the principle is going to be the same. What you
Yes.
can't do directly, you can't do indirectly. So,
Correct.
and I think, Catherine, you sort of spoke to this earlier. The sort of bribery landscape has sort of moved on significantly from bags of cash. And if crypto is going to be the new flavor of the day, that crypto is going to be it. I don't think the mode of payment of the bribe is really going to add prosecution, change prosecution, or would need to be expressly mentioned to be able to come within the net.
I think that's right. I think, all of the complications of prosecuting a case that involves crypto transfer will exist here, but it's not going to be in a different principle. If it's something of value, it's something of value, and I don't think that will change.
Okay, wonderful.
Absolutely.
Thank you both. I just wanted to open it up to the audience to see if there were any additional questions. Feel free to use the raise hand function and we'll call on you, or type it in the chat if you have any additional questions. Oh, I believe there's another one in the chat, and I'll just read it out. It says, also, like FCPA lays out responsibility on the corporates to have a robust compliance framework. As FEPA deals with the supply side, is it also talking about any responsibility for the corporates?
So
Oh, sorry, the demand side.
I see. Yeah, I see. And Shabir, jump in here as well. I mean, I think the responsibility on the corporate side and sort of the compliance infrastructure really comes into play by virtue of DOJ compliance guidelines and policies, the corporate enforcement policy, for example. And so, a company cannot have a compliance policy if they want to not have a compliance policy. That's obviously a risky decision, but the motivation for doing that comes from understanding DOJ precedent, DOJ guidelines, DOJ compliance policies, et cetera. And so I don't expect to see a huge change on that front. I mean, all of those same responsibilities still weigh on companies in the FCPA context. I think what this does is layer on sort of an additional complexity as you think about your compliance policies. And it sort of provides a good opportunity to revisit some of those policies and third-party policies and ensure that your infrastructure is accounting for some of these implications that we may see from FEPA. And it's entirely possible that DOJ may update their policies, and I would certainly be on the lookout for updated guidance as we move forward, and they kind of also feel their way through how they're going to start using FEPA.
I completely agree with that, Catherine. I don't think it changes anything as far as companies are concerned on the compliance program. I think if at all, it adds to an existing compliance outlook. I think Lokesh's question has sort of also touched on whether on the demand side. I think all in most countries, and I'll speak for India, we have fairly stringent rules that govern the conduct of government officials, and we actually have fairly aggressive prosecution results, and and prosecution. So I don't think that there's going to be, would FEPA translate for a country like India into tightening of norms? I do not foresee that happening, but I would foresee that in several other countries, which probably may not have the level of sophistication when it comes to regulating the conduct of government officials. Going back to the broader point I raised about getting conversations started.
Okay, wonderful. Thank you both. Are there any additional questions from the audience? Going once, going twice. Okay, awesome. This has been really, really informative. Thank you both so much for joining us today. To kind of sum things up, we will obviously be kind of tracking how this plays out here at USIBC. And we have recorded this webinar, which we'll upload onto YouTube and share with our membership. If anybody in the audience has any additional questions they would like to ask afterwards, feel free to reach out to Amy, myself, Catherine, or Sherbir, and we'd be happy to connect with you. And that's it. Thank you so much, everybody. Feel free to have a great rest of your morning, a great rest of your evening. And like I mentioned, just feel free to reach out about anything and everything. We're here to help.
Thank you for having us, Peyton.
Yeah, Catherine
Thank
and
you.
Cheerio, thank
Thanks
you
for
so
having
much.
us.
This was great.
Bye.
All right.
Good night.
Bye, everybody.